Hello aspirants. So today I am going to talk on recent presidential reference to Supreme Court under Article 143. It is a current affairs on Indian polity class. So let's look into Indian polity. So we are going to discuss the current issues related to presidential reference. Presidential reference under Article 143. So this has been in news quite for a long period of time since the judgment given by Supreme Court on Tamil Nadu governor case. There has been a lot of legal issues been coming up. So we'll try to discuss and we'll try to uncover those things. And some new concept of deemed assent has also come out of this judgment, and in the presidential reference it has been mentioned. So let's look into briefly the whole entire case and issues. So the president on May 2025 have referred to the Supreme Court under Article 143 seeking legal advice. So basically under Article 1, what is Article 143? Article 143 is where the president can seek advice from the Supreme Court in case of a question of law or public important issues. So in that context, president has referred the case. Now, what was the context? The context was April 2025 judgment. The context was 2025 April judgment by the Supreme Court on Tamil Nadu governor case. Tamil Nadu governor case. So in this judgment, in this Tamil Nadu, state of Tamil Nadu versus governor of Tamil Nadu 2023. Finally, the judgment came on April 8th, 2025. So what is the case about? The case was basically about where the Tamil Nadu government has taken the case to the Supreme Court regarding they have passed 10 crucial bills. 10 crucial bill which was lying with the governor for these many years, and the governor has not given assent. Governor has not given assent to the bill. So we'll look into the issues of Article 200 and 201 also. So in this context, what the Supreme Court has to say? So let's understand little bit about Article 200 and 201. So Article 200 is about where if the bill is being passed by the state legislature, it goes to the governor for the assent of the bill, right? It is about the assent of the bill. Assent of the bill by the governor. And Article 201 is regarding the reservations of the bill. Reservation of the bill by the governor for whom? For the president, right? So what the options, what option is available to the governor? The governor either he can give assent to the bill or withhold assent, or can return the bill if it is not a money bill, return the bill, or can reserve the bill, right? These are the options available to the governor. And there is no time limit, no time limit mentioned in the constitution related to like how long the governor or within what time period the governor should give assent to the bill. There is no timeline mentioned in the constitution, and that has resulted in the governor sitting over the bill, crucial important bill. And in that context, the government of Tamil Nadu has taken the case that the governor has not been giving any assent, or there has been no action from the governor regarding the very crucial bills. And you know, without laws we cannot govern, right? Law is crucial for governance, or it is the basis for governance. So now in this judgment, the April 2025 judgment, Supreme Court has said that governor cannot indefinitely delay the bill. Governor cannot indefinitely delay the bill. Governor cannot indefinitely delay the bill, or cannot sit over the bill for indefinite period without taking any action. That would amount to unconstitutional action. Unconstitutional action. Because in some way the inaction on the part of the governor is leading to or stalling the governance, because the crucial law is not being enacted, right? So that is what the Supreme Court has told in 2025, that the governor cannot indefinitely delay the bill, and they have given some time period, they have given some timelines. So they have given the period of 3 months. So once the bill goes to the governor, either he has to give assent to the bill or withhold, if he has to tell that he is withholding the bill, for what reason, he has to provide the reason, right? And whatever the action, it has to be completed in 3 months. And suppose the bill has been re-enacted and repassed, again it goes to the governor, then the governor must sign within 1 month. So these two time period has been given, that at the first instance 3 months can be delayed, and at the second instance when the bill is again repassed or re-enacted and again it is sent to the governor after the reconsideration, the governor has to sign the bill within 1 month. And now what happens to the president? If the president, this is about under article 200, where the president has to put his assent. And what happened under article 201 when the president has to put the assent? So once the governor reserved the bill for the consideration of the president, and that is, of course, it is in, he works in his discretion during that time, that it is his discretion to reserve the bill for the consideration of the president, and that relates with article 163. So be focus about all these articles I am talking about. I have talked about article 143, I have talked about article 200, 201, and then also I am currently talking about article 163. So 163 is that where the governor can act in his discretion. Generally the governor should act on the advice of council of minister, right? But there is a constitutional provision under article 163 itself that he can act in his discretion. So in his discretion he has reserved the bill for the president, that is article 201. Now when the bill is reserved for the presidential assent under article 201, then either the president can give his assent or withhold his assent, or return the bill, right? So there is a provision of absolute veto by the president, but of course there has to be, whatever he is taking the action must be communicated. It must be communicated to the state, right? So in this case the president has also provided timeline, because in the constitution again there is no timeline, but with this judgment they have provided the timeline. They have provided a timeline of 3 months. Even the president should, in the maximum period of 3 months, they should act and they should finally take decision on the bill which has been reserved, right? Now here the questions another concept that comes here, if the governor or the president, they do not take action within the stipulated period of time, that would amount to deemed assent. Deemed assent. So let's look it into a little bit more detail here, because this is a new concept. Deemed assent. What is deemed assent? So Supreme Court in this particular case, that is the Tamil Nadu governor case, they have come up with the concept of deemed assent if the governor or the president, they do not act on the state bills within a stipulated period of time which has been mentioned in the judgment. It is 3 months, maximum period for the governor 3 months, and maximum period for the president, that is 3 months. Then it would amount to be deemed assent. Assent by default. Assent by default means the bill will be automatically deemed to be signed by the governor or the president, as the case may be. Right? So this is about deemed assent. I hope you got some clarity, where deemed assent means it is assent by default or by itself. In case the president or the governor, they delay the state bills beyond the stipulated period of time which has been mentioned by the recent Supreme Court judgment, and where the timeline they have given 3 months. Beyond that, if they are stretching, it is assent by default, deemed assent. That is what the meaning of deemed assent. What is the significance? What is the significance of deemed assent? So it is very, very crucial that as the law is required to run the governance or for the administration, and there are certain very crucial laws. In fact, whatever the laws is being passed by the state legislature, of course, they are passed with certain objectives and certain goals, and they should be properly enacted, right? And in a parliamentary form of government, the governor or the president, they are the nominal executive, right? The real executive is the government. The real executive is the government. They are answerable to the parliament or to the state legislature for any lapses of the policies. So the president or the governor, who are the nominal executive, they must not indefinitely delay the bill, or they must not put any kind of obstacle in the governance, right? And by delaying the bill for so much and many a time in an indefinite manner, they had been in somewhat kind of creating obstacle in the governance, right? So in that context, Supreme Court has come up with certain kind of timeline, that there has to be certain timeline. If at the center there is no obstacle in the functioning of parliamentary form of government, why there should be so much of obstacle at the state level? Why there should be so much of state obstacle? So to answer such kind of thing, the Supreme Court has given this judgment, which has come on April 2025. I hope till here you got clarity. And this judgment they have given under Article 142. Now you will say, what is Article 142? Article 142 is related to where the Supreme Court can order, provide any order or give any order or decree to do complete justice. As the protector of the Constitution, as the guardian of the Constitution, the Supreme Court is duty bound to see that the Constitution function in a proper manner, and each and every organ of the state, they also function in a proper manner. There should not be any kind of obstacle or injustice. So in that context, Article 142 is providing complete justice, and that work has been given to whom? To the Supreme Court. So Supreme Court has used this Article 142 quite a number of time, and in this context also Supreme Court has utilized Article 142, that in case if the governor or the president, they delay the bill in an indefinite manner, which is creating an obstacle for the administrations of the state or prohibiting the bills from getting enacted, in that context the Supreme Court can intervene to do the complete justice. And this is under Article 142 only you can say that the Supreme Court judgment in the Tamil Nadu governor case is, you can say, it is being contextualized, right? So I hope you got the clarity. We have talked about a lot of article. We will definitely at the end we'll try to revise everything so that you get the clarity. So I hope till here you got Article 142 we have talked about, and then Article 143, 200, 201, 163. Now after this judgment, I hope you got the clarity of the judgment, why the judgment was important. Now after this judgment, of course it has the mixed reactions. The judgment got the mixed reaction, and some people they liked it. Obviously the states were happy with, because they felt it is good for federalism and it's good for functioning of the state. At the same time, there are certain section of the experts, they feel that it is going beyond separation of power, or it is a case of judicial overreach, where judiciary is trying to intervene in the action of the executive or act of the executive. It is judiciary versus executive issues. Because the judiciary is providing timelines to the executive for the assenting of the bill, which the constitution has not provided. So now we can say that constitution has not provided so many things, right? And we have seen the judiciary, and it is the Supreme Court who is the final interpreter of the constitution. So Supreme Court has come up with the interpretations, and they say that it is unconstitutional to delay the bill for indefinite period of time, and they had come up with the judgment. Of course there could be the mixed reactions, and in this context, the president has referred the bill. The president has sought the advice, not referred the bill, it has sought the advice that whether Supreme Court can give any kind of advice, or Supreme Court can force the executive, that is the president or the governor, to give assent to the bill within certain period of time. Whether timelines can be dictated by the Supreme Court to the executive in the context of assent to the bill. And on and all, they had asked around 14 questions. 14 legal questions has been raised under the recent presidential reference. One related to the timelines, and also another important issue was deemed assent, issue of deemed assent. So we already have discussed these two things, that regarding deemed assent we have understood the concept, and whether the Supreme Court can provide timelines. Now in this case, Supreme Court has been making observations. They have not come up with the final say, but a five judge constitution bench has been set up under Article 143, and Supreme Court has been coming up with the observations that if there can be judicial review, for Article 356, if there can be judicial review for Article 356, that is President rule. Why can't there be judicial review for 200, Article 200 and 201? So if there could be judicial review related to President rule, and judiciary can come up with certain kind of solutions related to misutilization of Article 356 or unconstitutional use of Article 356, which we have already seen in the Bomai case, in the Nebam Rabia case, that how judiciary has been asserting its role, and asserting its roles means basically trying to protect the constitution, trying to protect or try to balance the federal form of government, and trying to see that the center not unnecessarily dominating the state, right? So through the various judgment, the Supreme Court has come up with the solution. We have seen in the Bomai case, we have seen in the Nebam Rabia case, and with the very recent case also you can say that the Supreme Court has tried to provide a solution to the federal imbalance, or you can say the center domination over the state, which is somewhere creating the imbalance in the federalism. So that's what the Supreme Court has observed, that if there can be judicial review for Article 356, why can't there be judicial review for under Article 200 and 201, and why cannot Supreme Court utilize Article 142 in this context, that is related to Article 200 and 201, for providing certain kind of timelines that within which the governor or the president must sign the state legislative bills, so that the state government should also function, or state should also function in a smooth manner. Center should not create any kind of obstacle in the functioning of the state. So I hope you got a good idea. So let's revisit the entire thing. So this topic was related to the presidential reference under Article 143, and in this we have talked about the various provisions of the constitution. We should keep into mind Article 143, 200, 201, Article 142 as well, that is complete justice. Then Article 163, where discretionary use of power by the governor. All these articles are interrelated, related to this case. So let's revisit. Presidential reference under Article 143, in the May 2025, the President of India has referred the case to the Supreme Court regarding the previous judgment, the very previous judgment which came on April 2025, related to that there should be timeline for the assent of the bill for the governor as well as president in the context of state legislative bills. So before that, we have already seen that the Tamil Nadu judgment case, where the Supreme Court has provided the timeline, 3 months for the governor in the first case, and then again 1 month in the case of when the bill is being re-enacted and passed to the governor. So maximum 4 months the governor can delay the bill, not more than that, under Article 200. And when the governor reserved the bill for the consideration of the president under Article 201, the president should also take action within 3 months, otherwise it would amount to deemed assent. Deemed assent means assent by default. Yes, so we have already seen the concept of deemed assent, where if within the stipulated period of time, if the assent is not provided by the governor or the president, as the case may be under Article 200 and 201, then it would amount to be deemed assent or assent by default. That's related with which bill? State legislative bills. Yeah, so then we have talked about there has been after the judgment there was definitely mixed reactions, where some people or some particularly the states, they welcomed the Supreme Court judgment, but the center definitely they were unhappy with that the Supreme Court is trying to put some kind of time limit, or it is overreaching its role, or it is against the separation of power, and in that context the president's reference was made to the Supreme Court, and final advice has to come, because anyway it is advisory in nature. The Supreme Court either can give the advice or can, it is not binding on the Supreme Court to give advice, or neither it is binding on the president to accept the advice. But yes, some observations for the Supreme Court, that they have said that if there can be judicial review of the presidential action under Article 356, why can't there be judicial review of Article 200 and 201? So, and under Article 142, Supreme Court has already said that it is, Supreme Court is duty bound to provide complete injustice, and in that context they can take any action. So I hope you got the clarity related to Tamil Nadu governor case, the judgment, and also the recent presidential reference. Hope this session you would have find it useful to get more clarity on the issues. Thank you, and we'll keep on coming on this kind of current events and current issues on the various aspects. Thank you. All the very best.